क्या हमारे देश के प्रधानमंत्री के फैसलों पर भरोसा नहीं किया जा सकता? क्या देश के सबसे शक्तिशाली पद की नीयत पर शक करना सही है? दोस्तों, ये तीखे और हैरान करने वाले सवाल किसी आम इंसान ने नहीं, बल्कि देश के सॉलिसिटर जनरल तुषार मेहता ने सीधे सुप्रीम कोर्ट के जजों के सामने दागे हैं। मामला है मुख्य चुनाव आयुक्त यानी CEC की नियुक्ति का। साल 2023 में सरकार एक नया कानून लाई, जिसके तहत चुनाव आयुक्तों को चुनने वाली कमेटी में प्रधानमंत्री, एक कैबिनेट मंत्री और विपक्ष के नेता को रखा गया, यानी सीधे सीधे सरकार का 2:1 का बहुमत। इसी बात पर माननीय सुप्रीम कोर्ट में ऐसी तीखी और ऐतिहासिक बहस छिड़ गई, जिसने न्यायपालिका और सरकार को आमने सामने खड़ा कर दिया। जहां सरकार का कहना है कि प्रधानमंत्री के पद का सम्मान होना चाहिए, वहीं माननीय सुप्रीम कोर्ट के माननीय जस्टिस दीपांकर दत्ता ने एक ऐसी बात कह दी जिसने पूरी बहस का रुख ही पलट दिया। जज साहब ने कहा, बात प्रधानमंत्री पर अविश्वास की नहीं है, बात यह है कि क्या देश की जनता को यह पूरी प्रक्रिया निष्पक्ष दिखाई दे रही है। आखिर कोर्ट में क्या हुई वो तीखी नोकझोंक, और माननीय सुप्रीम कोर्ट ने अब क्या बड़ा कदम उठाया है, आइए समझते हैं।
On the particular section, you advanced your submission.
For only one thing, my lord. I'm sorry with
If you have not advanced your submissions, please do it. We are ready to hear you.
Lord, I would request
But
your lord.
don't expect a piecemeal judgment that we will deliver one judgment for whether reference is required or not, and then
That
go
is
on to
our
the merits.
specific request.
We will, if we have to, we will do it. But after hearing you on the merits.
Lord, kindly see my interpretation. Lord, kindly come to page 10, 145.
Page.
The minimum number of judges who are to sit for the purpose of deciding any question. Now, we are not in, my lord, now dispute that it is a substantial question.
Right.
No? And it involves interpretation of constitution, correct? My lord? Any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference shall be filed.
Shall be.
So, my lord, if
Now let us go to the Supreme Court rules. What does the Supreme Court rule says? Because 145 deals with rules of court. Correct? Now, what has the Supreme Court in its rules said?
Yes.
If that be the case, Mr. Solicitor,
Order.
all 32 petitions should go before a 5-judge bench. Why should it be placed before a 2-judge bench?
My lord,
You cannot invoke 32 unless...
it's a constitutional submission, your lordship may not be angry.
Mr. Solicitor, who is getting angry?
Yeah, my lord, it's order.
It's only that, I don't require a microphone. You also don't require it.
Yeah, no.
We don't require microphones because our pitch is a bit high. Attorney, of course, requires.
We request to.
Just one few. When you talk of reference to
Now, microphone.
when you talk of a reference to a large constitutional, just in this only. So the rules assist the court in a given context whether this matter would require to go before a larger bench or not. That's why in that Patel's case, your lordship says conclusive authority. If there is a conclusive authority, then of course the court, whether 32 or appeal, doesn't have to go to a larger bench. Therefore, we are trying to understand whether Anup Baran was reliant for this court at a second round of litigation will be a ground for issuing a mandamus is a question which we have placed in my written note paragraph 19, that these are questions which have arisen for the first time. If they have arisen for the first time and there is no conclusive authority, then of course the court will ordinarily, unless there is something to the contrary, which persuades the court that we don't get into that exercise at all, then of course the court says if something has arisen for the first time, to repeat no conclusive authority.
Test this. Attorney, please test this.
That's how it is.
Please test this. 32 petitions are filed. If an earlier decision has conclusively decided,
Your lordships will apply.
we will immediately dismiss the 32 petitions.
You offer
But
that.
if we don't immediately dismiss 32, if we issue notice, that means that we are satisfied that there is no conclusive authority.
No, lordships may consider whether
And therefore, we go ahead with hearing these cases even in combination of
Yeah,
2,
that-
combination of 3.
that will be an abstract proposition.
No,
In a
not
given
an
case,
abstract.
no, in a given case,
Let us see
even
what
if
the Supreme Court
there is
rules
such-
provide.
Would your lordship see rule
What does it provide? Can you
Supreme
please,
Court rules.
you also assist us by telling us what is
Rule 38.
Rule
Order
38?
Order 38.
Order 38.
38, petition under Article 30. Let me assist your lordship. No, forget the
50. What about constitution benches of 5?
first, my lord, for my satisfaction. I have, my lord, 38 rule 1.
Order 38 is
Common
at page
38.
58 to 61.
Your lordship gets, my lord.
Yes.
Number 1. Every petition under Article 32 of the Constitution shall be in writing and shall be heard by a division court of not less than 5 judges, provided that a petition which does not raise a substantial question of law as to interpretation of the Constitution may be heard and decided by a division court of less than 5 judges, and during vacation by the vacation judge sitting singly. But this is, my lord, the rule. Now kindly see, my lord, page 20 of my written submission. I am persuading your lordships. And my lord, I have no difficulty if the constitution bench is constituted next week. It's not that.
You may not have any difficulty, but the difficulty is on the judicial side.
That may not be a ground not to refer.
No.
That's the only respectful submission I can make.
No, we will definitely consider your submission, but we would have immediately referred if a 2-judge bench is precluded by the Constitution or even by the Supreme Court rules from hearing this matter.
I have shown out Order 38, Rule 1.
That is with regard to 32.
These are all 32.
It can be even heard by a vacation judge sitting singly.
Unless, my lord, please read it again, my lord.
Right.
I'm sorry, my lord, please read it for my satisfaction. Every petition under Article 32 shall be in writing and shall be heard by a division court of not less than 5 judges. Now, only exception is provided that a petition which does not raise a substantial question of law as to interpretation of Constitution may be heard and decided by a division court of 2 judges. It is conversely worded. We are not raising such grounds generally, my lord. Otherwise, this is the law. Once, my lord, we are ad idem that it is a substantial question of law and question of law pertaining to interpretation of the Constitution, then 145(3) read with this rule mandates that it has to go before a 5-judge bench.
Here's the point.
Order
6. Order 6. Okay. Order.
It's a big order. So which
Constitution of, all of it will be read. Constitution of division of
no,
court
we'll go.
and powers of a single judge.
We go.
Two, my lord. It would be 2, but it is regarding cause, appeal or other proceedings. But 32 has a separate specific rule.
Subject to other provisions. But this order 38 is specifically in respect.
Not,
32. Order 38.
not. Your lordships will read both of it together in terms of general. That's all I'm saying. That is true. That's specifically for it. I don't deny that.
This issue of
Wait a minute, let me complete.
Just 1 minute.
this issue of whether a case which raises a substantial question of law has to be referred to a 5-judge bench has been decided in a large number of cases, saying that if that question of law has already been decided by a constitutional bench, then it need not be referred. Several judgments.
Of course, I have cited Malad those judgments.
But this particular law is being tested for the first time.
So 324,
The law made by the parliament.
under 324 is for the first time.
Just one second. Every case involves something which is being tested for the first time. Every fresh case involves something. The question is, what is the substantial question of law which has not been decided? So we have challenged this primarily on the ground that a provision or a system which allows the government to dominate the selection of the election commission violates democracy and free and fair elections. And this has been settled by Anup Baranwal squarely. Then, my lord, the question arises whether the people appointing an election commission, whether the people appoint or whether a law which provides that the people who appoint the election commissioner will be dominated essentially by one of the parties who will be in dispute or who will be involved in issues to be decided by the election commission. That issue also has been decided by several constitution benches of this
That's
country.
not the issue here.
Judgment, including that central.
That's not the issue here. That's not the issue here.
This is we are dealing with a specific statute,
Yes.
right? Therefore, whether the parliament in conferring the authority on the prime minister to select the third member in the committee, this question has not been answered.
Actually, it has
Your Lordship, kindly turn to paragraph.
said in Anup Baranwal that the government itself deciding who is to be appointed the election commissioner is violative of the principle of democracy and free and fair elections. Ipso facto, this law, which says that the government will still dominate the appointment by a majority of 2:1, also violates that. So therefore, the court provided in
No, Anup Baranwal cannot be taken to be the last word in respect of a law which was not born on the date the decision was rendered.
Not at all saying that they could not have replaced the Chief Justice with somebody else. And they could have. But to replace the Chief Justice with another minister to be appointed by the Prime Minister leaves the selection entirely or essentially in the hands of the government, which has been squarely held to be violative of free and fair elections as well as democracy in Anup Baranwal. That's the argument.
No, sir. There the problem is.
Yeah.
But for the line in paragraph.
Of course,
Stop the parents.
we have challenged that law. Of course, they can. No, Lord, that line doesn't mean that if they bring a law, which is directly, suppose they had brought a law saying that the government will appoint. They had brought a law saying that the government will appoint. Now the question is whether such a law, when it is challenged on the ground that it violates democracy and the principle of free and fair elections, would raise any substantial question of law which has not been decided by this court, by a constitutional bench of this court.
That's not
In
a
fact,
question.
once this principle that if the government dominates the selection of the election commissioner, it violates free and fair elections, has been decided by a constitutional bench of this court. And therefore, my lord, that is no longer res integra.
Yes.
May I please also? My lord, first of all, I must show to your lordships that it was only on 20th hearing before your lordships that the question was raised for the first time that 145(3) applied when the learned Attorney General started his argument. That shows, my lord, the union was also not sure that it is required to be heard by Constitutional Bench of 5 judges. In the reply,
No, please wait. But for the attorney, it was the first hearing.
no, my lord, it is the learned attorney is appearing for the Union of India.
It was
The Union of India.
For the first time, he appeared and argued the matter on that day.
My lord, that all that I'm saying, my lord,
But
whether the
you
Union
cannot-
of India was.
You cannot give.
No, I'm not, my lord. That is only one on the.
20 hearings where you people have argued the matter.
We argued the matter, my lord.
No objection when his turn came.
My lord, that's what I'm saying. We argued the matter. The petition was there. It was heard from time to time. On the 20th occasion, my lord, when after we finished our argument, the reply is filed at that stage. Even in the reply, this argument is not taken. So, my lord, please, in the counter affidavit, this is not taken.
Not taken.
That shows, my lord, the Union of India is also aware that this does not require to be gone into. Otherwise, the first preliminary submission in a counter affidavit on the first date or the second date would be, my lord, that it required to be referred to a larger bench, my lord. That is not taken. That is one. Secondly, my lord, what are we arguing? We are arguing, my lord, that the law which has been made presently is violative of the constitutional provisions as interpreted by Anup Barnwal. As interpreted by Anup Barnwal. Otherwise, my lord, if your lordship is to read Order 38 and Rule Article 145(3), every petition, as my lord just said, every petition has to go to the 5 judges bench. 2 judges bench can never hear it any matter, my lord. Every matter raises some questions of law of public importance, and the judgment which learned solicitor, my lord, referred to in his judgment. May I read that judgment, which summarizes, my lord, in what cases it is to be referred, in what cases it is not to be referred. The learned solicitor and learned attorney has quoted the judgment. My lord, may I just place the judgment in its entirety? That is it is Srimant Balasaheb Patil. You have referred it. Learned attorney solicitor is also referred it. In it, may I just place that judgment?
Just read one sentence, the conclusive.
Yes.
That's most important. Nothing else is important.
Let me place it. Let me place it. Kindly give it to. Sorry, I have one copy. If your lordship kindly see, my lord, this judgment, page 649. The question which arose in this case is whether a person who is disqualified under the 10th schedule, he be disqualified for the rest of the term, or he can contest it again. That arose for the first time before the Supreme Court, my lord. Though there were plenty of judgment that arose, that specific questions, and in that reference, my lord, at page 649 of this, and this is perhaps the only judgment, and the judgment says, my lord, that now 145, what are the cases falling under 145 is never discussed, my lord, in any of the judgments. If your lordship kindly see, my lord, para 155 onwards. It's by 3-judge bench of this your lordship's court, my lord. This also arose for the first time, my lord, whether he should be barred from all times to come till the term of the legislature is over, or a disqualified candidate can seek a re-election. That is the question which arose. And 155, Mr. Sibbal, Learned Counsel, contended that the matter herein involves substantial question of law which require a reference to a larger bench. To support the argument, he has referred to Article 145(3) of the Constitution to state that this court is mandated under the law to refer the matter to a larger bench, since substantial question of law concerning the interpretation of the Constitution has arisen in the case. Then, my lord, Article 145 is quoted. Then 157. There is no doubt that the requirement of 145(3) of the Constitution has never been dealt with extensively, and more often than not has received mere lip service wherein this court has found the existence of a case law which has already been dealt with the propositions involved and rejected the reference. My lord, my submission is that the propositions which you are raising are already been discussed and laid down in Anup Barnwal. Normatively, this trend requires consideration in appropriate case to ensure unmeritorious reference do not necessarily consume precious judicial time in the Supreme Court. In any case, we feel that there is a requirement to provide a preliminary analysis with respect to the interpretation of this provision. In this context, we need to keep in mind 2 important phrases in Article 145(3) of the Constitution, which are substantial question of law and interpretation of the Constitution. By reading the aforesaid provisions, the conditions can be culled out before a reference is made. The court is satisfied specified that the question involves a substantial question of law as to the interpretation of the Constitution and determination of which is necessary for disposal of the case. We may state that we are not persuaded to refer the present case to a larger bench, as the mandate of the aforesaid article is that this court needs to be satisfied as to the existence of substantial question of law on the constitutional interpretation. However, this does not mean every case of constitutional interpretation must compulsorily refer to the Constitution bench. Any question of law of general importance arising incidentally or any ancillary question of law having no significance in the final outcome cannot be considered to be a substantial question of law. The existence of substantial question of law does not weigh to stakes involved in the case. Rather, it depends on the impact of the question of law, which will have a final determination. If a question having a determinating effect on the final outcome have already been decided in a conclusive authority, then such question of law cannot be called a substantial question of law. In any case, no substantial question of law exists in the matter which needs to be reference to a larger bench. The cardinal need is to achieve judicial balance between crucial obligation to render justice and compelling necessity to avoiding prolonging of an illness. Similarly, similar questions arose to refer a larger bench in Abdul Rashid, that also been quoted, wherein this court rejected a reference as questions sought to be referred were already settled by an earlier 5-judge bench. Likewise, this court in Bhagwan Sarup had substantial question of law interpretation of a constitution cannot arise when the law on the subject has been finally and effectively decided by this court. The same is provided hereunder. The learned counsel suggests that the question raised involved in the interpretation of the provision of the Constitution, and therefore the appeal of the accused to have referred to a bench of 5 judges under 145(3) of the Constitution, only a case involving a substantial question of law as to the interpretation of the Constitution shall be heard by a bench of 5 judges. This court held that that a substantial question of law interpretation of the Constitution cannot arise when a law on the subject has finally and effectively decided by this court. Now, what you all may read and then make my submissions, Lord. As the question raised has already been decided by this court, what remains is only application of the principles laid down to the facts of the present case. We cannot therefore hold that the question raised involves substantial question of law as to the interpretation of the Constitution within the meaning of 145(3) of the Constitution. This court, sitting in a bench of 3 judges in PUCL, has reiterated the above principle. In the light of the above pronouncement, we observe that the question of constitutional interpretation will arise only if the 2 or more possible constructions are sought to be placed before a provision. In spite of assertive arguments made by Mr. Sibal, we are guided by the decision rendered by 2 Constitution Bench judgment of this court in Quixote Holland and Rajendra Singh Rana case. These decisions form the authoritative framework of understanding the 10th schedule and have been followed in a large number of judgments and do not require reconsideration. And finally, my lord, it has been declined. So, Lord, my submission is, Lord, what are we saying? Before this impugned act, my lord, the scenario was, the provision was, the cabinet will decide. The president decides by the council on the aid and advice of the council of ministers headed by the prime minister. So, entire cabinet, my lord, under the rules of business, whomsoever is to decide, they take a decision. This has been frowned upon by a lordship, and lordship has said in Anup Barnwal that the executive exclusively, means, my lord, dominantly or, my lord, mainly, cannot have a say in the appointment of the election commission. That is the ratio of Anup Barnwal. As this will affect free and fair election. This will affect, my lord, the independence of the election commission, which decide the list between the government and the opposition parties also. So, my lord, this act has only, my lord, made the same thing, which was the scenario prevailing earlier, that under the rules of executive business, the president was to decide on the advice of the prime minister by his council of ministers. Now, my lord, prime minister, a minister chosen by him, and the leader of opposition decides. My lord, the scenario which was there before the Anup Barnwal case and the post-election, post this impugned act, has not changed. If it has not changed, the ratio of Anup Barnwal will apply squarely before your lordship, lord. If your lordship is to read theoretically Article 145(3) and Order 38, Rule 1, my lord, then every petition, each and every petition has to go before 5 judges bench, my lord. Then it can never be heard. And there are judgments which...
Submission that these petitions do not involve any substantial question.
It involves, but it has been answered by Anup Barnwal, my lord.
Anup Barnwal,
yes,
is binding. You have to find out what portion is binding and what portion is guiding.
Please, your lordship.
Binding is that till such time a law is enacted in
Yes.
terms of 324, the panel shall comprise inter alia the Chief Justice.
Please also.
This is a binding direction which cannot be violated by anyone.
Please, Your Lordship.
So far as the other observations are made,
Yes.
these are in the nature of guiding principles as to why the Chief Justice should be included
No, they-
even as a pro tem measure.
Lord, these are the principles
This-
of interpretation of the
Basically,
Constitution.
The question that is arising is
Yes.
whether Section 7 is ultra-vires
Please, Your
to
Lordship.
the Constitution.
And ultra,
Can there be any such question of law higher than this?
my Lord, it cannot, my Lord.
It
Lord,
involves
there-
the
my
entire
Lord,
polity.
There,
Now, where is this concluded authority?
my Lord, there are,
Where is that concluded authority that this section has to be held ultra-vires?
my Lord, this is, of
He-
course, my Lord, my Lord,
This,
there are,
this requires a consideration.
my Lord, this,
This
my Lord, there are
requires
judgments which are even
And we are bound by this
no,
38.
even the Constitution amendments have been
We are
struck
bound
down.
by this 38.
No, I am not
Order
saying,
38.
that's what I'm
Let with 145(3).
as interpreted by our lordships, my lord, which say the questions have not been decided. If the question has been decided, which your lordships have said in.
Yes.
Well, I have a full-fledged note on this question.
May I say, my lord,
Just-
may I just say a few
There
things?
are at least 4 judgments, my lord, I want to place before lordships, which has struck down the constitutional amendments by smaller benches, which has struck down legislations enacted for the first time on the particular subject, struck down by 2-judge bench or 3-judge bench, my lord, of this honorable court. It's not that, my lord, every time a question, my lord, may I just hand over a list? I only said, my lord, I don't want to place those judgments. I've just prepared a list of those judgments and what has been there. And would your lordship kindly see this?
Yes.
In the first case, my lord, Constitution 97th Amendment Act was struck down. The question arose for the first time and it was struck down by a bench of 3 judges by your lordship's court, my lord, not 5 judges. Similarly, in Madras Bar Association Tribunal Reforms Act, my lord, has been struck down by a bench of 2 honorable judges of this honorable court. In the third case, my lord, the Assam Parliamentary Secretariat Allowance, that also raised for the first time, my lord, interpretation of Article 361B, which says, my lord, you cannot appoint more than 15% of ministers. Whether the Parliament Secretary become a minister or not, my lord, that is raised for the first time and decided by a bench of 3 judges. PUCL is very important, my lord. I placed that before your lordship earlier. In the PUCL judgment, my lord, in the first round, ADR judgment said, you must declare these as details of the candidates. Till that such time, the Parliament makes a law. Parliament made a law, inserted 31A and 31B, saying that you need to declare only this much and not all, which has been said held in the Parliament by the ADR case. And PUCL judgment struck down those, my lord, by a bench of 2 honorable judges, my lord. So, my lord, in all cases,
All these judgments,
yes, my lord.
is there any objection raised by the union
Yes, my lord.
that the matter must go to a 5-judge?
Yes, I'll just show that, please.
If it is there, show us.
May I just show that? In the,
How the court has dealt with it, let us see.
yes, my lord. 28 to 30. I don't have the judgment.
Because I have a compilation, I'll place.
Very well.
Same judgments, but my learned from Mr. Ansari, I'll place it. Kindly hand over the report first and then the compilation. Straight away, my lords. So you'll actually hand over the compilation to the court first. Yes. Yes. Because I have 7 judgments in that compilation where the issue was raised by one of the parties for reference and it has been rejected. Kindly give a copy to the union, to the attorney and the learned solicitor. There was total 8 judgments where this question has been raised in different contexts.
Very well, show us the
Yes, so Mullah, the first one, straight away, Lordships will have para 8 at page 4. This is State of J&K versus Thakur Gangar, the 1960. Well, then
I would like to see judgments post 2013.
I will straight away come to it.
So this is AIR 60.
Well, all right.
Don't
no
place
difficulty.
AIR 60.
Yes,
Place
your-
judgments post 2013.
Your lordships will have the most recent, but 2020. In fact, your lordships will have Madras Bar Association,
Where is
which
Madras
is
Bar
2026, running page 7. And my lords, in this, kindly a para 105. Exact same objection raised by the learned attorney there.
Page 105.
Correct, my lords. And in fact, it's headed also Attorney General's plea,
No, 1 minute. Page 10.
page 81. 81.
Page 80.
My lords have that.
Yes.
My lord Justice Sharma has it.
Yes, please.
Yes. Para, it's headed Roman 5, Attorney General's plea to refer the issue to a larger bench. During the course of the hearing on 4/11/2025, the learned Attorney General for India submitted that the Union of India has filed an application requesting that the present matter be placed before a larger bench instead of the bench presently seized of it. In principle, there can be no quarrel with the proposition that this court may, in an appropriate case, constitute a larger bench where issues of grave or substantial constitutional significance arise. However, in the present proceedings, the learned Attorney General has been unable to indicate any cogent or compelling reason that would justify such a reference. Article 145(3) of the Constitution mandates the constitution of a bench of at least 5 judges only where a substantial question of law as to the interpretation of this Constitution is involved. The questions which arise in this case concerning the Constitution, composition, qualifications, conditions of service, and functioning of tribunals have already been examined in detail by constitution benches of this court in earlier decisions, including MBA 1 and Roger Matthew. These pronouncements have in turn been consistently applied and elaborately dealt with in subsequent decisions in MBA 2, MBA 3, 4, and 5. The present case does not present any new or unresolved question that would require reconsideration of those precedents or departure from them. A reference to a larger bench would, in this circumstance, serve no meaningful jurisprudential purpose and would instead result in avoidable consumption of judicial time. There is an additional consideration of procedural fairness. The request for reference has been made at a stage when the hearing before this bench had progressed substantially and one side has already been fully heard. With respect, I say same situation here as well. A prayer of this nature ought properly to be raised at an earlier point in the proceeding so that the court and the parties may structure their submissions accordingly. Entertaining such a plea belatedly would risk undermining fairness in the conduct of the hearing. Finally, we cannot lose sight of the fact that the controversy before us directly affects the tenure, service conditions, and legitimate expectations of large number of individuals presently serving or aspiring to serve in tribunals across the country. More importantly, the persistent vacancies and uncertainty in the tribunal system have a direct bearing on access to justice for citizens whose disputes lie within their jurisdiction. Deferring adjudication by now embarking on a reference to a larger bench would only prolong this state of uncertainty to the detriment of litigants and administration of justice. For all these reasons, we are of the considered view that no case has been made out for reference under Article 145(3).
Where is the consideration of Order 38?
Well, Order 38 has specifically not been considered.
It was a writ petition under 32.
That's correct.
To
So,
which Order 38 squarely applied.
yes,
The court has looked into 145(3).
yes.
The court has given a ruling that the issue is covered by 4 Madras Bar Association judgments. Therefore, this is just a ploy to get away from the division bench.
Correct. I'll just say
Right.
one thing. Yes.
But we are on 38, on
Yes.
the language of 38, shall be heard by 5 judges unless substantial question of law.
Yes.
Once you accept that there is a substantial question of law involved,
Yes.
right, under 38, we have to refer.
So, we are saying our submission is substantial in the sense of an important question, yes. But substantial in a constitutional sense that it's undecided, no. Our submission is this is not a substantial in the way of an undecided for the reason. My lords will just have my note which I've handed over. I have extracted all the paras just for a moment. No doubt we argued it's an important question. It is. But is it undecided? Is the sole question. And on that, my lords will see. Where is my copy? Yes. Well, the first thing I have said, your lordships will have these Madras, page 3 of my note. My lords have my note, page 3.
Yes.
Abdul Rahim, learned solicitor, also cited. PUCR also was a case where reference was rejected. PUCL is also one such case. Then over the page, my lords, Jayashree Patil, your lordship said post 2013. Jayashree Patil is also a case where reference was rejected and the matter was decided, and it was found to be unconstitutional by a 3-judge bench. Then, my lords, Madras Bar I read. Now, my lords, serial number para 9. I'll show that. I'll show that. Yes, one second. My lords will have page 5 of my notes, para 9, Lily Thomas. Lily Thomas. Well, Lily Thomas was a case also of 8(4) of the Representation Act, where the Parliament had exercised the power pursuant to Article 326, not 324.
Lakshman Rao Patil
Yes,
was not a writ petition.
yes, it was a civil appeal. That's correct.
It was a civil appeal.
Well, may I say this on Rule 38? I will only say it actually reiterates what's there in 145(3), maybe more explicitly a little bit, but in fact it says the same thing. It doesn't really add anything new in my respectful submission. So my lords will treat 145(3) and 38 as effectively, my lords, identical. That's my respectful submission. Now my lords will have over the page at page 6. Statutory testing on constitutional principles, I say with respect, is always done by 2-judge and 3-judge benches of this court. Now, look at the list I've prepared. Shreya Singhal, number 1.
Why did it go to 5-judge bench, Arun Barra?
I'll give the reason.
It's there.
Para
it's
2.
there.
Para 2. I'm so grateful for that question.
Right.
My lord.
So what was the prayer? Direct the Parliament to legislate.
No,
as per 324.
The prayer, my lord is right. That was one of the prayers. I am so grateful for that question.
Please,
Kindly have para 2 and para 5.
Let us see.
Yes, my lords will have para 2 and para 5.
Page 147. 147.
One of the compilation, page 147. Kindly have para 5. At running page 147.
Para?
Para 5, my lords. This is one of the writs, and I'm reading the prayer in this writ. Para 5 at page 147.
Yes.
In writ civil 569 of 2021, filed by the Association for Democratic Freedom, the relief sought are as follows. Issue an appropriate writ order or direction declaring the practice of appointment of CEC and election commissioners solely by the executive as being violative of Article 324, subclause 2 and 14 of the Constitution of India. This was a specific prayer in one of the writs, the primary prayer, prayer A. Now, my lords, in that context, we'll have the order of reference at para 2, just the page 146. A bench of 2 learned judges of Anup Barnawal passed the following order on 23rd of October 2018. IA number 2 for amendment raised additional facts, grounds and praise allowed. The matter relates to what the petitioner perceives to be a requirement of having a foolproof and better system of appointment of members of Election Commission. Having heard the learned counsel for the petitioner and the learned Attorney General for India, we are of the view that the matter may require a close look and interpretation of the provisions of Article 324 of the Constitution of India. The issue have not been debated and answered by the court earlier. Article 145(3) of the Constitution of India would therefore require the court to refer the matter to a constitution bench. We accordingly refer the question arising in the present proceedings to a constitution bench for an authoritative pronouncement. So, insofar as the interpretation of 320, yes.
You have shown us page 147.
Yes, my lord.
Para 5.1.
Yes.
Has the 5-judge bench accepted this prayer and then said frame a law on the basis of what we have said?
So on that,
please
yes.
Read the prayer once again.
Yes, yes.
Right?
Yes.
Issue a writ.
Yes.
Declaring the practice so and so as violative of 324.
Yes.
What is the finding on this prayer?
Plus, there are multiple findings on this prayer. Your lordships will have, in fact.
And thereafter, what is the binding operative direction that has been given? That by the executive, it is bad. Therefore, we are including the Chief Justice of India as one of the members of the selection committee, and that this has to be followed.
So, before I show, I'll just answer it in short. Your lordships, as a part of Article 141 in Barnawal, have held that non-executive dominance is a requirement of Article 324 for a selection committee. Non-executive dominance. And that's part of a ratio of Article 141 under Anup Barnawal. On the relief, which is the outcome, your lordships modulated the relief, saying since the Parliament has not enacted anything, in the interim, the CJI will be one of the members. That's the relief. not the legal authority under Article 141, which is independent, which I'll take my lords through. I'll just place the para straight away. So, my lord, there are two different aspects. What have your lordships held to be a constitutional mandate as part of Article 324? That, in my respectful submission, is that the committee which selects the CEC and the ECs has to be non-executive dominant. It can have executive presence, but it should not be dominated by the executive. When we have Prime Minister and a Minister of his cabinet, that means executive dominance. So it's straight in the teeth of the constitutional interpretation by Anup Barnwal. That, as short as that is our respectful submission in this matter. There's really not much beyond that. On the paras, I'll straight away, your lordship will have first my note. I put all the paras at one place. Kindly have, my lords, in my note, page 13 of my note, my lords, page 13. Because, my lords, it obviously the court has found different things at different points in time. My lords, I have divided it in heads as to what has been held. My lords, A, the core holding that the law contemplated by Article 324 subclause 2 cannot be executive dominated. This is there in all these paras, my lords, which I have referred in one form or the other. This has been held that they cannot be executive. This is interpretation of 324 binding under Article 141. Number two, the basis of this has been found in the Constitutional Assembly debates at para 33, 34, 35. That's B. Then, my lords, Article 324(2) contrasted with other subject to law provisions, because there was a subject to law here. So, wherever else Constitution also has subject to law, those provisions have been dealt with also. Then, my lords, the separate one is Justice Rastogi's concurring judgment, and E. And, my lord, Justice Rastogi's judgment reiterates in 424 to 463 what is in Part A. And then, my lords, in E, independence as substantive content of the requirement processes in these paras. So these are all, my lords, clear-cut ratios. Today, there is a constitutional mandate on the parliament to have a law which is non-executive dominant. They could have, my lords, had n number of combinations.
Where is that particular
Yes, so, my lords,
direction that the law should be non-executive dominated?
my lords,
Where is that
your lordships
direction?
will have
If the Constitution bench intended
yes, my lord.
that
Yes.
on the basis of the reasoning provided here,
Yes.
why did it stop at saying that?
So, my lords, your lordships will
Right.
see, your lordships sitting in the Supreme Court will never say that a law has to be of a particular type. Your lordships will set the constitutional threshold for the law. And that's the language and the manner in which my lords have done it. Kindly have para 297, page 260.
No, if that be the case,
Yes.
that court
Yes.
would not direct parliament or legislature to legislate in a particular direction,
Yes.
right? If court has no such power, even the Supreme Court does not have that
That's
power,
correct. That's correct.
right?
Yes.
And the court is conscious that the parliament has not yet framed the law. Why would the court spend so many paragraphs and not say that this is the way the law has to be? Why did it have to say so many things? Why?
Because they were interpreting Article 324.
It was not required. 324 says parliament should by law provide the mechanism.
Yes.
It has not been done for 70 years. You say, Parliament, this is what the Constitution requires you to do. This is what the nation expects of you. We hope and trust you will act in terms of the Constitution.
My lords will
That's the end of the matter.
My lords will just
But the court does not do it.
yes.
Court provides sufficient reasons, goes into 324.
Yes.
Was it required for the purpose of the final relief that there should be a law?
My lords, may I say why? It possibly was. I'll
So if it was,
yes.
the court should have also given that direction.
No.
Like Vishaka.
I
Like
appreciate
Vishaka.
the question. No, I appreciate the question. What I'm saying is, in 297 in other paras, the court has said that you have to have a law which is non-executive dominant. Now, how you reach that non-executive dominance is left to the parliament. You can have n number of combinations, my lords. When we were arguing in the opening, my lord suggested something. On our side, there were 3 or 4 suggestions. There are n number of possibilities. The principle which is laid down as a part of constitutional law under Article 324, that the committee of selection cannot have executive dominance. And that's exactly what the parliament does in the teeth of the constitutional principle. That's all we are saying in this. So, my lord, it does not therefore require any reference at all. My lord, on
Para 301, very clearly said.
301.
yes, 301 in it.
Yes.
That's right.
It says the law could not be one to perpetuate what is already permitted, namely appoint the absolute and sole discretion of the executive. Yes, it. Therefore, to now bring a law, essentially, not sold. This kind of law hard. Law laid down in Anup Baranwal, which says this will destroy
Mr. Bhushan, we quite understand. Why did the court stop?
because
Why?
it was that now with so much that we have said about the need not to have an executive dominated selection committee for the election commission, the new law will abide by what we have said. We don't need to say that the new law, of course, they could not have said that it must have the chief justice. It need not have the chief. But it cannot be dominated by the government. That comes out throughout the whole basis of the judgment for striking down the present that if you have a system of selecting election which is not of fair elections and so on. And they stop short. Kind of power. They can't say who else will be brought in or who.
Connected to your internet.
Therefore, they didn't say. Otherwise, my lord, they expected that the law will abide by the principles laid down in this judgment.
And in paragraph 456, it is a declaration. Paragraph 450 of Warren Bath, 456, Lord, may I kindly have a glance. It is a declaration based on an interpretation of Article 324. It's a declaration based on an interpretation of a constitutional paragraph 456. Paragraph 456. In order to allow independence in the functioning of the election commission as a constitutional body, the office of the chief election commissioners as well as the election commissioners have to be insulated from the executive interference. This is envisaged under the proviso to Article 324(5), which reads, then my lord, the provision is Article 324(5) is quoted. Therefore, my lord, it is a declaration given in Barenbal which binds them, which even my lord, even the parliament cannot get rid of, my lord, at least in as a matter of constitutional principle and interpretation of Article 324(5).
Paragraph 22 of this judgment. 222. The election commissioners, including the chief election commissioner, blessed nearly infinite power and who are to abide by fundamental rights, must not be chosen by the executive exclusively and particularly without any objective yards. Now, here they say exclusively because at that time the government was choosing them exclusively. Now, Lord, Rule 38, as Mr. said, is essentially reproducing Article 145. Now, 145,
open it and keep
interpreted repeatedly.
Article 145.
In every case, my lord, the interpretation says only such question of law which has not been decided by. And I submit, my lord, this question of law as to whether the government, the dominant power of selecting election commissioners can be with the government by any law has been settled not just in Anup Baranwal. It has also been settled in India. It has also been settled in that Madras Bar Association. Central Organization of Railway Officers, which says that even the power to select an arbitration panel, if it is given to one of the parties, and therefore that cannot be allowed. Same thing, my lord, in Madras Bar Association, that the power to select members of tribunals, etc., to the government is also struck down. In NJAC, my lord, a constitution amendment is struck down merely because, my lord, one of the members of the selection committee happens to be the law minister and the secretariat is placed under the law minister. So therefore, my lord, this question has been settled conclusively. Therefore, the question of law is no longer res integra. Once it has been settled by several constitution bench judgments of this court, then, Lord, it is not a question which can be referred under Article 1 or which should be referred under. Otherwise, Lord, it would mean that any time a question of law arises in an Article 32, it will make the whole system completely unworkable. Every case has to be referred to constitution bench. Almost every 32 petition will have to be referred to a constitution.
Well, just
And
one.
there's a judgment, not on the point, an early judgment. Once the matter is referred to and decided by a larger bench, what will be the role of the subsequent smaller bench, numerically smaller bench, and whether there has to be a further reference. There has to be a further reference was the contention raised, which was repelled in that 1955 judgment, where there was already a constitution bench judgment. Let me kindly have a glance at paragraphs 14, 16, and 17 of that judgment. That is Rao Shiva Bahadur Singh. I will give a copy. Rao Shiva Bahadur Singh judgment. Paragraphs 16 and 16, 14, 16, and 17. 1955, 1 SEC 539. Where, Lakshmi, please to see this. Whether once it is decided whether it was a case where an appeal was, certain constitutional issues were raised. Those were initially decided by a 5-judge bench. The 5-judge bench in turn relegated the matter again to a smaller bench, having the judge strength of 3. Then a question was again raised. The 5-judge bench should have decided the whole thing. And in that case, the 5-judge bench was again constituted. And it was held in paragraph 16. You lost me, please to see. The consideration that there is no such general rule as is relied on by the learned counsel, and that the splitting up of cases is not generally repugnant to the law and in particular to the constitution, leads us to the conclusion that in construing clause 3 of article 145, no quality of invisibility need to be attributed to the words any case used therein. A case may, to begin with, involve a substantial question of law as to the interpretation of the constitution, but it may cease to do so at a later stage. Likewise, when the constitutional question involved in this case are disposed of by the constitutional bench, that I am relying on heavily, what remains of the case cannot properly or appropriately be described as still a case involving a substantial question of law as to the interpretation of this constitution. But that dichotomy is very, very significant. What is contemplated under Article 145.3 is not a substantial, not just substantial question of law, but a substantial question of law pertaining to the interpretation of this constitution. That part of it has already been dealt with in Baranwal. Therefore, this is the reason why a second reference will be totally uncalled for. I have filed a separate written submission as well, Milo. Because any substantial question of law, the Form 20 of the under the Supreme Court rule says that anything should have a substantial question of law. But that is not enough for a reference. If that be the case, as Farasat has already been pointing out, but everything will have to be decided to a larger bench because of the existence of a substantial question of law. That is not enough. It should be a substantial question of law with respect to the interpretation of this constitution, which in the case on hand only means.
Just one point of supplemented.
Very critical.
My lords, we have some submissions to make. So your lordships can just indicate whether your lordship will continue on some date now.
Lord, I will also have to make certain submissions because I was waiting, Milord, for my turn.
The provision we are considering the devastation, one second, of continuing to leave appointments in the sole hands of the executive on fundamental values as also fundamental rights. We are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists on the basis of which unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a mere transient and stopgap arrangement, and it was to be replaced by a law made by Parliament, taking away the exclusive power of the executive. The conclusion is clear and inevitable, and the absence of law even after 7 decades points to the vacuum. And 297 also, my lord. Para 297, which says, we have set down the legislative history of 324, which includes the reference to what transpired, which in turn includes the views of members of the and members of the Constituent Assembly. They unerringly point to one conclusion: the power of appointment of the members of the Election Commission, which was charged with the highest duties and nearly infinite powers, and what is more, to hold elections not only to the central legislature, but also to all the state legislatures, was not to be lodged exclusively with the executive.
What does this mean? That the legislature has to step in by enacting a law.
Making a
And
law.
that has been done. Now the question is whether the law is in accordance with the constitution or not.
But that,
Right?
that question, my lord,
Very good.
has been.
We are reserving
The
order on the
constitution
question
bench.
of reference. Mr. Parekh
My
and
lords, we
Mr.
need to
Gopal,
address
you
your
can provide
lordships.
your written arguments.
Just
My
one
lords,
thing if I can
I'm
point out.
sorry, my lords, we were under the impression that they were going to argue on
We
merits.
were also under
They
that
were supposed to
impression,
argue on
Mr.
merits.
Gopal, since this point has been raised, we have heard your learned friends here.
No, there is quite something to be said on this point of reference,
Mr. Gopal,
particularly with reference from the Constitution itself. Article 145(3) proviso needs to be read to your lordships. It's not the Supreme Court rules alone. This provision needs to be read. Let us address your lordship.
The proviso
Was read by me.
Yes,
have any application here?
that's precisely the point. That proviso deals
We are giving
only
you
with
too many
appeals
time, you
from.
satisfy us that 145 the proviso has an application here.
Yes,
Please,
if your lordships
come
just
to
sees the
proviso,
provision.
please read it.
Yes, I'm just reading the provision. It says, provided that where the court hearing an appeal under any of the provisions. So the Constitution is very conscious of appeals, not writ petitions,
So
appeals.
therefore, this does not apply. This does not apply.
The point I'm making is, considering that the rules, if your lordship sees the opening clause of 145(1),
Yes.
145(1) says, subject to the provisions of any law made by Parliament, the
Yes.
Supreme Court may from time to time, with the approval of the President, make rules. The rules are therefore subject to that. Now, under 145(3), which is the constitutional provision itself,
Rules are
it's
not
very
under
clear.
challenge. These rules are not under challenge.
No, they're not under challenge. They're not under
Right?
challenge.
These
What I'm
rules are
pointing
not
out
under
is,
challenge. And
what
this
I'm
does not say that these rules are subject to provisions made by law by Parliament.
no,
Subject
I'm
to
saying,
the provisions of any law made by Parliament. If Parliament has made any law with
Yes.
regards to matters covered by 145, then of course
now the
we
point
would have
is
to
slightly
assess
different.
whether the rules
Well,
yield to the Parliament made law or not.
Yes,
Right?
the point is slightly different. The point I'm making is
So, sir,
that the
Mr. Gopal,
proviso
your point,
provides
referring
for a
to
mandate.
proviso is not at all well
No,
founded.
let me just
If you have any other
just
point,
explain.
tell us.
Let me just
We are
explain, my
short
lords.
on time. You please provide it in your written argument. If you
My
feel
lords,
that
your
yes,
lordships have
some
been
clarification
Lord.
very
we'll come
generous
back.
in granting time for
May,
this
may I
particular
say
hearing.
something,
So
Vinod?
I'm just
Understand
seeking
that
maybe
this is a
15-20
broken bench
minutes
that
on
we
the
have
next date.
assembled.
I understand,
Please provide,
which is why I'm
please
saying
provide your
it's,
written argument.
it's a very important issue. Just give us 15-20 minutes, my lords. If it can be done on some other date, 15-20 minutes. Just
Look here. Please give
Yes.
your written argument. If we find that there is something of consideration which requires to be put to the other side also, we'll definitely bring it back.
Well, there is one immediate fact,
May
which
I-
is the nine questions which have been.
The proviso has no application here.
So let me just take you to the 9 questions that the solicitor has framed.
We will not
Well,
sit only for that purpose.
I'm only on the 9 questions formulated by the solicitor. If your lordships have had a chance to see pages 3 and 4 of his written submissions, none of those 9 questions are substantial questions attending the interpretation of the Constitution. None of them.
All of you have argued that these are substantial questions.
No, we have not. We don't accept that any of those questions are substantial questions.
Important, but not undecided.
Nothing to do with the interpretation of the Constitution.
Placing the written submission.
What about the question as to whether the writ petitions ought to be referred to a bench of 5 judges is
My submission also.
My submissions, Vinod, because I was here waiting for my turn.
submissions.
Now I know it cannot be heard.
And Mr. Shankar Narayan, learned senior counsel.
Sanjay Parekh, my lordship's motion.
Huh?
I am, my lord, because I could not be heard, I was present here. I'll also give my submissions.
Yes, please.
We have said so.
Yeah, lordships have said
Mr.
so.
Parekh and Mr.
Yes.
Gopal Shankar Narayan are permitted to file their
I couldn't hear.
written-
I couldn't
Grateful.
hear.
We'll give it in writing then.
Please give it in.
We also file short written.
Please do.
Yes. Yes.
ये करो. All the parties, नाम काट दो, all the parties.
Grateful, grateful, grateful.